Court calls the case of the people versus Marquesi Hankey.
Then we have to keep your order.
Good afternoon, Your Honor. Attorney Kevin Hassan, except one here.
All right, it's your motion.
Caretaker for. So at the very least, the restriction is phone privileges to contact them.
All right, well, before I hear from the people, counsel, let me just say, you came in here the first time, and, well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they he cut the tether off. We haven't seen it. Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, you know, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your mom gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you until I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing. And then, why stop now if they already know?" So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kid say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay. Right now? All right.
So just, if I may, just briefly, my client would like to support.
Go ahead.
I apologize. I don't think I'm being bad at all. First about myself. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. So, again, please show mercy. Please. So, thanks.
I have no problem showing mercy to those that deserve it and have earned it. You have not. motion for bond reduction or any change is denied, his bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I know that's if possible, but it's if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 9 a.m. in person before Judge Perry. That's right. Court does call the case of the People versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and I'm here. James Dennis Whitley.
This is People's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my client
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say.
Rule number 1 of lawyering. Never accuse the judge of playing favorites unless you want to see a 25-year career flash before your eyes. Attorney Jeffrey Bennett just suggested the court is biased toward the prosecution. Watch the judge's face. This isn't just a disagreement anymore. It's an insult to his life's work. The tension just went off.
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock, with 24 hours notice, I could have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not.
The charts.
Because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Teenage District Court of County, Washington. Teenage District Court of County, Washington.
Court recalls the case of the People versus Whitley. Court recalls the case of the People versus Whitley.
Assistant Prosecuting Attorney.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newtown. Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newtown. Beginning to state your name, stating, please, my right. James Dennis Whitley. Beginning to state your name, please. James Dennis Whitley.
Let me just say this, Mr. Bennett. Let me just say I've been on this bench almost 25 years. And I've been on this bench almost 25 years. Have I ever been insulted? And never in the fashion have I ever been insulted. In very, no, my turn. In very, no, my turn. The case, the very first case, when you say the very first counsel or anybody else doesn't get access to the court like the anybody else, you are get access to the court like the prosecutor. The first case I called absolutely wrong was upon receiving a notification about something that I had receiving a notification about something that I had been located. Was notified that had been located to the defendant's benefit. This court set that hearing. Defendant's benefit without notice to any side. Hearing. I set the hearing without notice to any side. So to be fair to all of the parties. So to be fair to all of the parties. I receive motions all the time. I receive motions all the time. And this court just seeks to be fair, to have a hearing. This court just seeks to be fair, to have a hearing. Mr. Bennett, the desire just to lock your client up. The desire, frankly, because the decision came from a magistrate. Quite frankly, because the decision came from a magistrate, I could have changed that bond without a hearing. But I wanted to give the parties the opportunity to be heard. But I wanted to give the parties the opportunity to be heard. So maybe you can put that in a little perspective. Now, having said that, I heard you that you said you just got the discovery can't go through. I heard you that you said you just got the discovery can't go through it. Well, 18 hours to go through it. Because I'm adjourning this 18 hours to go through it.
to allow
Because I'm
you to go through the discovery to give me a cogent argument as to why I should not grant argument as to why, and secondly, not grant because you have raised the ire of this court. You have raised the ire of this court. By what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. From any counsel in all of my years. By any means, punish him for that. By any means, I do not make my decisions out of anger. I do not make my decisions tomorrow. May 10th. I'm adjourning this to tomorrow. All the parties are ordered to be here. Noon. That is all the parties are ordered to be here. That is all. That is all. Noon. That tomorrow is all. Noon. Tomorrow.
A revoked bond for one, and a bruised ego for the other. Today was a lesson in respect, both for the court's orders and the court's bench. If you're going to talk trash, don't do it on a recorded jail line, and if you're a lawyer, maybe don't insult the person holding the gavel. What do you think? Did the lawyer go too far, or was the judge being too sensitive? Drop a comment and let's argue about it. Don't forget to subscribe for more courtroom madness.
They're bringing him.
Yes.
They're bringing him.
Yes.
Have you seen it?